All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Thank you for being here. We're here in a case 1CA CV18-0287, CHALMERS versus CHALMERS. Each side will have 20 minutes to present their argument. Appellant, at any time that you want to save for rebuttal, you're welcome to, but it's up to you to keep track of your time. We have a clock at the podium for that purpose. We are recording the argument both in audio and video, so please identify yourself and your client when you begin. You'll be YouTube stars in a few days if you want to watch the argument. We've read the briefs and we've conferenced the case, so we're familiar with the facts and the issues. So when you begin the argument, just launch right in to what you want us to know and talk about. Counsel, you may begin.
May it please the court, Keith Berkshire for appellant William Chalmers. To begin, it's important that we're not actually asking this court to overturn the Rule 69 agreement. We're simply saying that what the trial court did by refusing to hold a hearing was the error, and we're asking that it be sent back for essentially what used to be called a sharp hearing. Our argument is that there was not enough evidence in the record, well, mainly because there's not much of a record, to do the independent duty as outlined by this court recently in the Hutkey case, which actually came out after the trial court ruling in this matter. So essentially in this matter, sharp would have been the presiding standard at the time when the court did this hearing, which is actually, I believe, a little stricter standard than what this court illustrated in Hutkey.
But it isn't the state of the record the responsibility of the parties? So if the record is slight, it's not the court's fault.
Well, but the issue is, in this case, is when you're going to review a Rule 69 agreement and basically summarily adopt it. So the cases Wick, Sharp, and Hutkey have progressed by different procedural postures. Sharp was a motion for summary judgment. This was essentially a notice of lodging and a motion to enforce. The issue is that if the court is going to proceed and adopt an agreement without evidence in the record, or adopt an agreement without a hearing, there has to be something in the record that the court can do that independent duty on. Our claim is that because there wasn't anything in the record, no trials, no affidavits attached to the motions, like in Hutkey, there was apparently business valuations and correspondence and things attached to the lodging documents.
Was it your obligation in objecting, or your client's obligation in objecting to the agreement, to provide some basis to demonstrate a specific factual dispute, not just a broad objection? I mean, what would the court's determination that there's a plain factual dispute?
Well, the issue here is my client did, in his objection, raise various claims regarding separate property, the pain and suffering, money, waste, equalizations, and so forth. The issue, I don't think, can be put on him to show that there wasn't enough facts in the record, or let me restate that. The issue isn't that he has to prove there's not enough facts in the record. The court is the one with the duty here. This isn't upon either party. For the court to adopt this, as has been the law for 47 years since Wick, the court has to do the analysis. We're saying that the court can't do the analysis if there's nothing in the record. Now,
so you're saying if two parties reach agreement, both of them sign, both represented by counsel, both conduct their due diligence, resolved, the court still has an independent duty to comb over that document and assure its fairness.
If objected to, yes.
Okay, so if objected to by one of the parties who entered into the contract, you signed the
Correct.
contract.
Correct.
Okay.
And
Is that automatic? It's just you can sign a document, conduct due diligence, and then say, you know what, I didn't mean that. Or is there some higher standard that we will require of the trial court before it has to revisit the equities of the document your client signed?
Well, and that's been the dispute since Wick. I mean, it's been the dispute since Sharp, clearly, is what do we have? I mean, if we go back to Sharp had this, you know, I'm not sure how much Hutke really modifies it. Sharp was, because it was very similar facts, that Sharp had put forth a standard that the proponent of the agreement has to prove by clear and convincing evidence that's fair, which has somewhat been changed by Rule 69, although I'd argue a rule can't change a statute. But they still have the obligation. I mean, the Supreme Court said this in Wick, that you still have to look at it. It still has to be fair. So the objection, once there's an objection made, the court's obligation is automatic. And then it's what's in the record. So let me use a kind of ridiculous example. I get my stuff, you get your stuff, is the agreement. 5 minutes after we file the petition for divorce. There's literally nothing in the record. I get mine, you get yours. Mine happens to be $50 million. I allege that when I object to the decree, or my wife, when she objects to the decree, I have $50 million, I get $1. The court has the duty. It's not on one of the parties. It's once there's an objection, the court has the duty. Now, if there was for example, a lot of our Rule 69 agreements have spreadsheets, because every divorce comes down to a spreadsheet. So it's, here's my stuff, here's your stuff, here's the actual equalization, here's how it's calculated, here's the business value. There's enough in that record, because there's a spreadsheet. There's enough data there for the court to do its duty and say, well, I looked, this is pretty equal, versus the I get my stuff, you get your stuff analysis. And that's why I think the distinction in Hutke is important. Clearly
Well, to take your example, far specificity has to be made in the objection. If you have, to take your example, if I get my stuff, you get your stuff, and then the one party says, that's not fair.
Well,
then does that automatically trigger a hearing, or does there need to be some explanation of why it's like
well, if one of the parties allege, for example, that the distribution is $10 million to $1, that would trigger a hearing if there's no evidence in the record. Now, if there was resolution statements, pretrial statements filed that had these numbers in them, it would be different. But
it's unfair. That's it. I want you, court, to take a look at it. It's unfair.
I think under Sharp, the allegation of unfairness alone triggers the court's duty. I think the court's duty upon any objection is what this court has said the Supreme Court in Wick has said for 47 years. You have an independent duty to look at it. If you have no evidence, if I say it's unfair, now the court has to look at it. And if that's the kind of two-step part of this. If they look at it and there's a spreadsheet, perfect, that's enough. But if there's nothing, the court has to take evidence. I mean, the cases in these is when this court overturned when this court overturned or discussed Sharp in Hutke, it said that there was nothing in the evidence where the court could have determined the agreement was not unfair, discussing Sharp, because there was nothing in the record. Here in Hutke, there was stuff in the record. There was clearly affidavits and business valuations and other things that were put as part of the record to show that the agreement was that there was numbers to it. If there's no numbers, there's no way the court can do its independent duty because there's nothing to look at. That's when the hearing is triggered. And that's when I think the Sharp and Hutke cases talk about if there's nothing in the record, we're not saying set it aside summarily. We're saying you don't have enough in the record to do your duty, therefore that triggers the hearing. And that's all we're asking for.
So by the very utterance of the words, this is unfair, then the burdening shifts to the other party to put forth evidence about why it's fair, or else the court will have to find in your favor simply because you issued the statement, this is unfair?
Again, the other party could point to the record and show how it is, or point to the evidence that would support their argument.
So your argument is that by saying, I am Chuck, this is unfair, the burden immediately shifts to the opposing party to prove why it's fair.
And the burden shifts to the court to expend the resources to hold a hearing because your client in this case neglected, or his counsel neglected, to ensure at the time of the agreement that there was sufficient information.
Well, and again, I mean, this case
Or
is...
sufficient information in the objection. I mean, the example that you give of you take your stuff, I'll take my stuff, even in your example, the objection was, well, but that means $10 million here and $1 here. We don't have any of those evaluations either in the agreement or in the objection, do we?
In the objection here, I believe, stated enough that would put this as disputed issues of fact. I mean, that there's enough about that she got separate property, there was not property disclosed, the issue with this extremely valuable computer software, the issue with the pain and suffering claims and the other separate property. There was enough, therefore, disputed fact that the court had to do something. It's like on a motion for...
That's the standard disputed fact. So it's not just objection, it's objection grounded in disputed fact. Is that your answer?
I have a hard time getting around the 47 years here of that the court has some duty to look at this independently, that they have to review it. Okay, this isn't contract law. Family court has never been contract law. We've always had the big brother of the court. You know, normal contract, you sign whatever, too bad. In family court, there's always been, under Wick and Sharp, and which we have followed until last summer when Hutke came out. There's always been this: the court has to approve it theory. It's not simply contract law. So I've always been of the theory that, again, especially under Sharp, which would have been out at this time, which was the proponent of any agreement has to prove that by clear and convincing evidence that it's fair. That was the standard when this came out, when this case went to the court. So I think the utterance of the objection under Sharp clearly does it, because Sharp clearly put the burden. Okay, so here, I think now with Hutke out, I think having some disputed facts, unless the court has evidence in it, in my ridiculous $10 million, $1 objection, I submit an objection that says their bank statements are $10 million, I had $1. I think the court would have to look at that and could overturn it.
Taking an example where husband gets $50,001 and the wife gets the remainder for the so that they get $2 less in the division. If the wife says that's unfair, then the court has to have a hearing, or can look at that and say, well, you're out $2. I don't see this is unfair. I don't see you need to have a hearing.
Well, and that's actually similar to the facts of Hutke. I mean, this court in Hutke found that there was a disparity and still adopted the agreement. I think the disparity was rather large, in the couple 100,000 range. But they had evidence in the record to do that. So in your situation, or your example, Judge Howe, it's, there's something in the record. Again, one of the keys...
all we would have is the number.
But again, but that goes back to when this court, when Hutke was interpreting Sharp, that the reason for the reason in Sharp that the agreement was overturned, this court found in Hutke that the court had no evidence to the extent of the community assets. So when they adopted the agreement, and they further, one of the further things here, and I think that in this court's opinion in Hutke is that why the one Sharp was overturned was this court said in Hutke that the dispositive minute entry had no basis on how the trial court could have determined the agreement was not unfair. That the minute entry in Sharp didn't say anything, like how they determined it was not unfair. In Hutke, the opposite is true, where the trial court's minute entry in Hutke, which is vastly different than the trial court's minute entry here, trial court found they had full knowledge and access to all information. Everything had been disclosed. They had valuations done. They had information about withdrawals of money. Then the main thing in this is the trial court in Hutke, which did not happen here, the trial court found the agreement was carefully negotiated and created an equitable division of the party's assets. So the trial court in that case found that, which is the necessity here. The trial court didn't find that here. The minute entry here just said husband didn't allege enough or didn't state enough to set it aside. There is in Hutke, the trial court clearly did the independent duty to determine whether it was fair. Here they didn't do that.
Let me ask you, counsel, in paragraph 27 of Hutke, it says, and I quote, in terms of law, Sharp indicates a court is required to undertake an independent determination as to whether the distribution of property in an agreement is fair and equitable where a case involves plainly disputed facts on the question of the fairness of the agreement, and the court was presented no evidence as to the extent of the community assets. Is that saying that a mere objection triggers some inquiry into fairness?
I believe so, specifically the last part of that, and was plainly disputed facts which husband disputed here in his objection. He disputed the fairness, the equalizations, the separate property nature of the reimbursements, and when the court was presented no evidence as to the extent of the community assets. Here, again, we have the Rule 69, which is it turned into the decree. I mean, the court just signed the Rule 69 essentially via minute entry and turned it into a decree. Doesn't list out the extent of community assets. You get this account, I get this account, here's an equalization. There's nothing in there that gives the scope of the community assets. And that's why we believe that there has to be a hearing, because there has to be some ability of the court. If the court is going to determine fairness, they can't say, well, I see there's an equalization of $55 over here, and that you each get these accounts. But how can I determine if this is fair if I don't know what's in the accounts? They can't look at it because there's nothing in the record. And that's what I believe these cases, the issue here is husband objected about facts, about specific allegations, and there was nothing insufficient on all the assets in the record. If bank statements had been submitted, if here's all the claims, here's the equalizations, mediation memos, which is clearly what happened in the trial court in Hutke, where there were affidavits and true facts put into the record prior to the court hearing that, business valuations, things like that. The court looked at all that additional data that wasn't looked at here. Again, we're just asking simply whether that entitles us to a hearing, not that we're saying this court should set it aside.
So your position is that the court, because of its duty to independently determine fairness, cannot look at the objection made and say, you know, this is not enough to trigger a hearing. The very fact of the objection necessarily triggers a hearing. The court errs as a matter of law in saying, you know, this objection is not enough to force a hearing.
I think it's the court obviously doesn't have to hold a hearing under Sharp and Hutke. I'm not saying they have to. I'm saying that, as was just stated, the issue is there enough in the record that they can adopt it without holding a hearing? Is there enough evidence in the record to adopt it? So if I objected and say I got an extra $1, or my husband got an extra $1, the court can be like, well, you admit that we don't have to do equitable isn't equal. But when they allege significant things that my client did, that if they don't have enough, they have to do a hearing. It's like summary judgment. You can't do it if there's a disputed fact. You've got to actually find enough evidence in the record.
Our standard of review of the trial court's determination that a hearing wasn't required. Would you say that that's an abuse? The standard would be an abuse of discretion? I
guess the issue.
The court got it wrong, but
again, I think
point of view.
I think from the standard that they misapplied the law, they misapplied whether they had enough evidence in the record. I mean, they especially under Sharp. I mean, Sharp was the standard at this time. Sharp, it's on the burden on the proponent to do by clear and convincing evidence. Every court followed Sharp up until Hutke came out. Every judge thought that was the law. So clearly they misapplied it under Sharp, that there was clear and convincing evidence that it was unfair. The issue is, and I want to say my last 1 minute, was...
But Sharp, just real quick, Sharp, wasn't it the objection was I was coerced to enter this agreement?
And this court specifically found in Sharp that wasn't proven, that there was no evidence in the record of coercion. This court did not rely on coercion or duress in Sharp at all.
And it pivoted to fairness.
It absolutely pivoted to fairness. Then this court's citation in Hutke to Sharp, that Sharp does not rely on it. They specifically find that duress was not proven. There wasn't evidence of this. Just because you were under pressure of criminal cases, which was what was going on in Sharp, that's not enough. So the court in Sharp did not rely on duress.
Okay, so we'll give you an extra 30 seconds so that you'll have a minute.
Thanks, Judge.
For a rebuttal. Counsel?
Yes, good morning. If it pleases the court, Angela Wilson-Goodman on behalf of Appellee Renata Chalmers. Your Honor, looking at the two cases, the Sharp and the Wick case, it really seems like, and I think that it's been picked up on here, it's kind of a two-part analysis. Like, not only do you have to say, okay, this is unfair, we don't think that this agreement is unfair, but there also needs to be some sort of evidence or allegations of duress, coercion, and undue influence. Wick says that. Wick says lack of evidence in the record and claims of duress, coercion, and undue influence. I'm sorry, Sharp says that. Wick also seems to indicate that there's a two-part test that says fair and equitable and free from fraud and undue influence.
But doesn't he say that there was undue influence, that he was threatened?
When does he say that? Because if you look at the records, Mr. Chalmers filed an objection to the Rule 69 agreement. Doesn't say that it's unfair. He doesn't ask for a fairness hearing. He doesn't say that I was under duress or I was coerced or was undue influence. The first and only time that Mr. Chalmers raises that duress and undue influence argument is in the motion for reconsideration that was filed in May of 2018, well after the court had already ruled, upheld the Rule 69 agreement, denied all of the objections, and we were moving forward.
Shouldn't we be especially sensitive to arguments of coercion where we have this representative capacity, these GALs? Isn't that a little different than your, I guess, standard case where the husband actually negotiates and signs? Here it's sort of one step removed.
I mean, yes, we obviously should be cognizant of that issue, but especially in this particular case, we have 3 lawyers representing Mr. Chalmers, all part of this mediation. We've got the family court attorney who's got experience in family court, representing the fiduciary and looking out for the estate. We've got the court-appointed guardian ad litem who's looking out for the best interests of Mr. Chalmers, and we've got Mr. Chalmers' court-appointed probate counsel. And so, I mean, it kind of begs the question, if there was undue influence, where did that take place? Was this kind of a conspiracy and all 3 of these lawyers ganged up on him? Okay, I mean, he hasn't alleged that. There certainly aren't any facts in the record to support that. If the probate counsel, Mr. Doyle, felt that the guardian ad litem was trying to exert undue influence on him, then Mr. Doyle should have put that in his objection when he filed the objection to the joint notice to lodge or to approve the Rule 69 agreement in the probate court. That did not come up at all.
So what kind of evidence? You're saying there was no evidence or argument of coercion until a certain point. when should that have been raised, and what kind of evidence are you talking about that would be sufficient? Like an email or?
Well, I mean, maybe a verified pleading to start. Like the objection was not verified. There's no affidavit. It's just conjecture and argument on the part of the attorney drafting it. There should have been some detailed facts that would have said, this happened, this happened, this happened, and this is why I felt undue influence. But then who else was under the undue influence? With guardian ad litem, who had the right under the statute to sign on behalf of the ward? The probate attorney? There was no allegation that the probate attorney was exercising undue influence, and he was certainly there looking out for Mr. Chalmers' best interests. I disagree with Mr. Berkshire that I don't think just making the allegation that this is unfair should be sufficient for the trial court to then have to say, okay, I thought I settled this case, but now we're going to schedule a hearing, we're going to take testimony, we're going to present evidence, and then that court has to make an independent analysis of the values of the agreement, because the agreement as a whole, the court has to find the agreement as a whole was unfair. So how do you quantify settling contested issues? How do you quantify waiving claims for disputed arguments that maybe you don't have a good chance of winning at trial? How do you quantify I'm going to get more parenting time or decision making, or I get to relocate, and I'm going to give my spouse more money in order to be able to do that? I don't think that Sharp and Wick, and I don't think that 25317 puts that burden on the trial court. I think if the trial court has to do that analysis, somebody has to come to the court with more than just gee, I have buyer's remorse and now this is not fair. There has to be some verified evidence, and I do think that it needs to be this two-part analysis. I don't think that it should be just, well, I think this is unfair, judge, have a hearing.
So, well, if the party alleged there was a conspiracy and was forced into this, would that be enough to trigger a hearing?
I still think you have to make more than just the argument. I think there has to be some sort of verified pleading, an affidavit, something that the court can look at and rely on, and facts supporting that. And in this particular case, you have three lawyers, on behalf of Mr. Chalmers, who are all tasked with looking out for his best interests or his estate's best interests under either the family court or the probate court. I mean, I guess we can't solve all problems, and if there's a conspiracy of all three of those lawyers, how do you prove that? Mr. Chalmers wasn't under a guardianship, he was only under a conservatorship. He certainly could have filed his own motion, which he did file motions while he was unrepresented at some points during the family court case, and he could have detailed out all these facts. It wasn't just the duty of the lawyers representing him, but he had the ability to do that. He had the ability to seek independent legal advice because he was not under a guardianship. It's got to be more than just a party saying, wow, I don't agree with these couple of issues anymore, now I want a fairness hearing. And he didn't ask for a fairness hearing. He was complaining about some of the allocations of property in the Rule 69 agreement, and he wanted it set aside under Rule 69. He wasn't saying this is unfair, give me a fairness hearing under Sharp or 25317.
The practice is different in family court, and that there's this special sensitivity to making sure that even agreements are fair, unlike, I guess, civil. Is that your experience without regard to any particular rule that the court is independently verify the fairness of an agreed upon term?
Well, to be honest, if attorneys are involved and there's a settlement agreement that's reached and that's submitted to the court and they sign off on it as a consent decree, in all my years of practice and all my cases and cases that have come to me, I've never seen a family court on their own refuse to enter into or sign off on an agreement because it was unfair, because they had done an independent analysis. I think that the trial court, I understand that the court isn't required to adopt it simply because it's an agreement of the parties, and that the court has the ability to go in and not adopt it if they find that it's unfair. But I think that the trial judges, especially in family court, which is so overburdened, they need to be able to rely at least on representations of counsel, and in this case, representations of 3 attorneys on behalf of Mr. Chalmers, that all of the I's had been dotted, all the T's had been crossed, all of the disclosure had been done, or to the extent they weren't going to do anymore. They had done the analysis, and in light of everything, the difficulty of going to trial, the problem of calling Mr. Chalmers as a witness, the liability, potential liability for him to have to pay a ton of attorney's fees because of his behavior. There were no kids in this particular situation, but there were all kinds of intangibles that had to go into the consideration of all of the people and the attorneys involved in determining as a whole this agreement is not unfair. And fair and equitable isn't in that statute anymore. It's the court has to find that it's not unfair. Somebody has to quantify some of these intangibles. It can't just be math. You can't just look at the agreement and say, okay, you got $100,000, you got $90,000. That's not equal, and so therefore we need to have a hearing to determine whether it's unfair.
And you had said you're not bound to divide 50-50 if you enter into an agreement, because there's leverage both ways, and you have a negotiated point that might account for all different sorts of concerns. So in that context, I guess, what would the fairness consideration be? I guess it would be a hearing, an evidentiary hearing, where you talk about the negotiating positions.
But how do you do that? I mean, how do you go in there and you start presenting evidence about your settlement negotiations, about your trial strategy, about your thought process, about what's important to you, what's not important to you? How do you present that type of evidence in front of a judge without completely destroying the integrity of the negotiated settlement process and confidentiality issues? How can a lawyer go in there and have their their client get on the stand and testify about stuff that was discussed between counsel and the client, that was basically privileged information? So you're asking the court to make their own independent determination on how do you value these intangibles to determine whether this agreement is unfair.
Talk about what would the ramifications be to the process, the dissolution, or the family court process, if we were to accept and agree with your colleagues' perspective on the proof, the burden it takes to revisit an agreement?
So, assuming that all it takes is for one party to file a motion to say this is unfair, doesn't have to show anything else, doesn't have no factual basis to get past that point. Every single litigant that has buyer's remorse, or who wants to get more leverage, or who wants to basically try to get a better deal, especially if they're the more financially well-off party, is going to all of a sudden say, okay, I know I said that I agreed to this, but you can't believe what I said. I changed my mind. I don't think it's fair. Let's have a hearing, and now it's going to cost you money. You're going to have to pay your attorney. We're going to show up. And so the court is just going to be inundated with a bunch, but they might as well have just set it for trial. Because then you've got pleadings that you're arguing, and then you got to have a hearing, and the hearing is going to be akin to the trial, because if you have to prove or disprove the fairness or unfairness of it, then now all of a sudden all the evidence is coming in about the values of the financials. And you have to make an argument about you're a good parent or you're a bad parent, and that's why I wanted more parenting time, or I wanted to relocate, and so that's why it was more valuable to me to, give up some financial aspects of it so that I could get my kids because you're a crappy parent. it's just going to be a litigation nightmare for the family court. Nobody's going to want to enter into any settlement agreements because nobody's going to want to risk that, gee, we thought we were done, but now we're not, and now we've kind of compromised ourselves because we've given concessions, we've negotiated away some of our leverage. Now we have to go back to the court and explain why we did that and why that's value and how we value it. I think the practice of family law is completely going to change the landscape. If a litigant has the ability to just go in there and say, gee, this was not fair, nobody's going to want to settle cases. They're just going to go to trial. If there's no more questions, I think I got through all of the key points that I wanted, and I'll save the rest of the time for Mr. McKindles.
Thank you, counsel.
Thank you, Your Honor. John McKinless appearing on behalf of the appellee, East Valley Fiduciary Services. I appreciate the questions that you pose. I don't have a lot of time. I'm not sure how you allocate the time, if I've got another 20 minutes or if I'm just taking a portion of her time.
The two of you had 20 minutes.
Okay.
You've got about 6 now.
Okay, that's fine. Thank you. I just wanted to follow up on a couple of aspects of this that I think are important, and that is the Rule 69 agreement can be overturned upon, or at least allows a challenge upon proof of a defect. There's no proof of a defect. There's been some discussion about coercion, undue coercion, and duress, although it was not raised properly before the trial court. And it should not be an issue that this court needs to concern itself with, at least in this case, because it wasn't properly raised in the trial court. I think also that in this case, if you remand this case, it's not going to be a fairness hearing. It's going to reopen this case for trial. It's going to reopen it for discovery and disclosure. The allegations that are made by the appellant are so vague, and they're basically based in what should have been done and what the assets should have been inquired into and claims that should have been inquired into. And he wants an opportunity to relitigate all of this, to reopen the case, to perform discovery. Of course, he wants the court to perform this discovery for him, but even without that, he wants an opportunity to go through and prove all of these vague allegations. He can't prove them unless he goes through further discovery, because that's the nature of litigation. You go through discovery. The discovery itself is not made a part of the record. I mean, the pleadings are, but what's discovered isn't necessarily made a part of the record. And so he wants to go through that, even though there was a huge quantity of discovery that was done in this case. He wants to go back and do more. There was a lot of money expended chasing rabbit holes that the appellant directed counsel to go through. And I second Angela's comment about what this does with settlement agreements or settlement conferences per se. If a party can simply challenge the validity of a separation agreement based upon some vague assertions of not being treated right, or of inadequate discovery or inadequate representation, you'll never find attorneys that are going to be willing to endure settlement conferences, nor would they expose themselves to potential malpractice claims because they expended tremendous energy and money of their clients to go through a settlement conference. And this is 10 hours of settlement conference. This isn't just an hour. We went through 5 hours with the number of attorneys involved in this at my offices, and we fine-tuned those issues that needed to be resolved. And I won't I don't want to take up too much time, so I'm cognizant of that, but there was a lot of effort made towards settling this. It wasn't just a, his stuff, her stuff, you keep what you want, I keep what I want or I have. This was heavily negotiated. And so he's not done yet. And that's the concern that I have for this case, frankly. And I'll leave with this thought. If there are other questions, I'd certainly address those, but I'll leave with this thought. If this is remanded, my belief is that Mr. Chalmers is going to come out worse than he did under the settlement agreement.
Thank you, counsel.
Thank you.
We appreciate your argument, counsel.
And I'll make a couple quick points. In Sharp, there was absolutely no evidence presented by wife that for the challenge of the agreement. She presented nothing. Neither party presented anything. She simply said it was not unfair, and the court held that was sufficient on the challenge. She presented nothing other than the statement that it was not unfair. The statement that this would evidently bring the family law system to a halt is, it's frankly laughable, because Sharp has been the standard for decades, and Sharp is a lot harsher standard than what this court said in Hutke. It has literally been, I've had multiple of these types of even appeals. There was a case I did a year and a half ago, Stone versus Van Stone. It was the exact same facts. There wasn't enough in the record. You needed a hearing, and this court overturned it and said you needed a hearing. There's nothing in the record. Beyond the fact that there's no evidence in the record on this, the other big issue is that the court's minute entry didn't say that it did the independent determination, where the Hutke one did. In Hutke, the trial court said, we did the determination, I found it equitable. Here, there was nothing like that. The trial court did not say it did its duty.
Counsel, thank you.
Thank you.
Your time is up. We appreciate your argument today. We'll take this matter under advisement and issue a decision in due course. We'll stand in recess until the next argument at 11:30. Thank you.